lady walks into a chiropractor's office for treatment one day. Little does she know that less than an hour later she would be leaving, wondering how her 18-month-old son had died. Welcome and thank you for joining me in this video. My name is Ben Schmitt. I'm an attorney practicing personal injury law and insurance law in Kansas and Missouri. In February of a given year, my client was involved in a small automobile accident. As part of that automobile accident, she sought care from a chiropractor for her neck and back injuries. The chiropractor decided that appropriate therapy would not only be the ordinary manipulation, but also something called traction therapy. Traction therapy is a therapy that uses a table to help heal a patient's spine. In this particular case, the patient is led into a small room. The only apparatus, the only thing in this room is the traction table. She is strapped to the table. Also led into the room are her 18-month-old son and two daughters, 5 and 3 years old. As part of the traction therapy, the patient must be laid flat on a table and then Velcro straps are placed to her arms. She's strapped down to the table in every manner. She's looking straight at the ceiling. Her children are seated along the edge of the small room. They've been given toys to play with by the chiropractor's office. The young boy, 18 months old, was given a toy car. He rolled the car along the floor and gave it a big push. The car rolled underneath the table. The table raises and lowers by operation of a foot pedal, very small foot pedal, roughly the size of a deck of cards. As the young boy reached through the table to grab the car, his knee landed on the foot pedal, lowering the table, resulting in his death. We contended that the table was, in our words, defective, unreasonably dangerous. Here is what was dangerous about the table. Number one, the table had no guarding on this pinch point that killed the young boy. Also, on the foot pedal, there was no aluminum hood like you see on many sewing machines today. There were no warnings in place. The table manufacturer denied that it was at fault in any way, and in fact, they blamed the chiropractor. We proceeded in a lawsuit against both. What did we do to help resolve this issue for our client? First thing we did was immediately go to the scene, at which point we took photographs of the room, the door hinges, the general area and layout. We also took photographs of the precise and exact machine that had caused this horrible death. Then we secured the machine. We stored it so that if it became necessary to look at the exact machine during the litigation, we had it. We had it available. Also, we tracked down the original designer of the machine, who was kind enough to share with me the sketch of his original design. Interestingly, we found that in his original sketch and design, he had designed in guards and warnings just as we thought it should have in the first place. We also tracked down other litigation involving the company that manufactured the machine. In that litigation, we received certain email from the company representatives, and it was incredible the callous attitude exhibited by this product manufacturer. We filed a lawsuit. It was required in this case that I hire certain experts. Experts in this case included a professor emeritus of mechanical engineering at the University of Minnesota. We flew him to the apparatus. He inspected it, and he found, as we suspected, that this machine violated very, very basic principles of engineering, including warning and guarding. More troubling about this machine, however, was the patient, my client, was given a button to hold in her hand during the operation, during her traction therapy. And the button it's called a panic button, panic stop. that if something goes wrong, you are to squeeze that and the traction will stop. Sadly, however, this button, as designed by the manufacturer, did not control the raising and lowering of the mechanism. It was our contention that about 30 cents would have saved this young boy's life. We also hired an expert chiropractor to discuss the standard of care for a chiropractor. Standard of care simply meaning how should a chiropractor act under these same circumstances. In this particular case, we found that the chiropractor too had violated the standard of care in that he was not present in the room during the therapy, nor was there any chiropractic assistant present in the room during the therapy. If that had been the case, this young boy would still be alive. In fact, evidence was going to show that the chiropractor was not even on the premises at the time this occurred. As litigation finished in this case, we went to a mediation session, which is a discussion between parties in an informal matter about settling the case. The case did resolve at that session before any further legal work had to occur. You're watching this video, chances are you have questions about a similar matter. In other words, you've been injured or you know someone who's been injured by a dangerous or defective product. Call me to answer your questions. My name is Ben Schmitt. My telephone number is 816-389-4014.